So I'll make a start. My name is David Hudson, and I am the founder and director of the HR department in Clapham. Delighted to have you join us. Just by way of introduction, I have been running the HR department Clapham for the last 6 years. I have over 25 years experience, including operational management and all manner of things. Just having recently before I started, come out of a corporate role, and I'm delighted to be here with you today. And thank you to everybody that has joined us. So without further ado, let's move on. I'm going to have to ask Kirsty to move the slides along. So if you could move on, please, Kirsty, to the over to you slide. So today we're going to talk through employment law changes in 2024. Cases in 2023 that will be worth thinking about, and then take some Q&As. So on the next slide, what would be really interesting is to hear a little bit about your experiences at the moment. So we are obviously facing a very difficult time, and I'm interested to hear what risks you are most concerned about for your business or your team. So if you could take, please, to the chat function, which is at the bottom of your screen, and pop in there the letter that pertains to you. So A, impact of cost of living crisis; B, losing talent; C, lack of skills; employee health and well-being; or potentially having to downsize. If you could share those with us, that would be super. Great, some answers coming through already. Thanks, Bella. Yeah, A and C. B and E, yes, absolutely, Rachel. Emma, yeah, A and E, thank you. Great, yeah. VJ, B, yeah, good. Yeah, losing talent, that's been a big issue. Something that we are certainly seeing is an issue across our clients. So excellent. Okay, thank you. And just to say, and apologies again for the bumpy start, but if you have questions about any of this or comments, or you want to share experiences, then please do that in the chat. I'll make time at the end of the webinar to get to your questions. Otherwise, we'll contact you, and my colleague Kirsty, who joins me from the HR department, also will make notes. And as I said, we'll come back to you when we can. Okay, next slide, please. So I'm going to talk to you about the key changes happening in 2024. As you'll know, the employment landscape is constantly changing and often needing to respond to the ever-growing economic and social and technological and political changes. There is a lot to contend with. So even if we just think about this year, I think it's fairly certain that there'll be another general election in the UK. The American elections and everything else around that means that it's still going to be quite a tumultuous environment for people to operate in. Kirsty, there's some people waiting to get in, if you could let them through. So there's a lot for us to contend with, and one of the main reasons why you can't ignore that is because they will have a direct bearing in some way or another on employment law. Obviously, the manifesto discussions are starting to warm up with the political parties. For example, I'm already being asked questions by people around how things might work if, for example, 0-hour contracts are abolished. So already people are starting to think about what's ahead. What I'm going to do is talk to you about what, for more certainty, is going to be happening in the next 12 months. So next slide, please. So first and foremost, it's important to note that the statutory rates are going to be increasing. So that's statutory sick pay, family leave pay, the national minimum wage, and the national living wage. A noticeable increase, as you can see here on the slide. One of the key points to note is that where previously the living wage was for only those over 23. From the 1st of April 2024, it's going to be for those over the age of 21, and that's going to be rising to £11.44. There's also some noticeable changes in things like maximum weekly pay for redundancy calculations and the total pay for redundancy, which creeps up to £21,000 from the start of the year. This is important for you to check and make sure that your own policies are updated, and indeed, if you're working with seasonal workers or hourly paid workers, that the rates of pay that you are paying them are in line from the from the start of April. So do please make sure you check, and we will send these slides out to you, but also the information is available on the government's website. Next slide, please. So one of the changes that you may or may not be aware of that happened this year was the change to the way that holiday pay is calculated. For those of you that are in HR, and welcome to you, there has been some quite kind of shifts and turns, if you like, in the way that holiday pay is calculated. And for the legal eagles amongst you, that came as the result of the Harper Trust versus Brazel case, which was a case about a music teacher that was working part year. It kind of really all sort of took us into a place which I think is fair to say was rather confusing around how pay was calculated, having also exposed the fact that the fairly long-standing way of doing it, which was to use what we call the 12.07 rule, wasn't actually even in itself in place, because that was removed by the Working Time Directive some years back. So the good news, I guess, out of all of that chaos is that we now have clarity on how holiday pay should be calculated for part year and irregular hours workers. And just for clarity, part year are we define as employees who have worked at least 1 week a year, but not every week per year, and irregular hours, as it suggests, will be what we know as, for example, 0-hour workers. And what the legislation now says is that they are entitled to be paid 12.7% during their pay period for leave that they've accrued. So how I guess this works in practice is that you may have, for example, an irregular hours worker and they work 5 hours a week. You could still give those people leave, if you like, technically, so they don't have to come to work, but they're paid as the accrued leave from the 5 hours. Alternatively, what this new legislation allows is that you can pay that person 12.07% of those 5 hours, and you will have then paid them for the leave that they've accrued. So you will want to go back and look at how you're dealing with your part year and irregular hours workers to make sure that those that leave entitlement in either way is paid. You will also want to go back and check to make sure that your policies are up to date, and also to talk to your payroll colleagues so that they also are aware of how these things should be working. But hopefully this will help. Certainly we find amongst our clients it's demystified what was really starting to be quite a complicated process of holiday payments. And we move on next then to changes to paternity leave. Previously for paternity leave, employees were able to take a period of 1 week or 2 weeks of consecutive leave whilst they were, preparing for a new family. The changes now is that employees can choose to take either a 1 week or 2 week single period or non-consecutive period of leave. So essentially, what this new legislation has done is it's become less rigid. So it's broken up the time that you take the leave and still requires the leave to be taken but it can be taken within 52 weeks of the birth of the child. So there is still a service requirement. So similar, for example, to other family-friendly leave, employees will have to have 26 weeks continuous service at least on the 15th week before the expected week of confinement. So a quirk, if you like, of working out paternity leave and maternity leave for those amongst us that have to do that regularly, but just be aware that there is a service requirement, and do contact us if you want some help around how that has to be calculated. Also, as I've mentioned on the previous slide, there is a statutory paternity pay, and that is going to be £184.03, which will start from April. So that rate of pay also goes up. The new leave that you may have seen introduced in the newspapers and online, etc., is the carers leave. And if we could go on to the next slide, please. Carers leave has been designed to recognise, if you like, that in the sort of environments that we're now in, people do need opportunities to take time off to care for people that may need them. And the carers leave is something that, if you like, is another indication of employment law slightly relaxing and moving more, I think, into what we see as the more day-to-day needs of employees. So it's really good. It's really good news. So carers leave is going to be what we refer to as a day one right, and that's going to be for 1 week, and the leave has to be taken every 12 months, and that's to provide care for a dependent. If the leave can't be taken, so if you have an operational reason, for example, that means that individual may not be able to take the time that they requested, then they have to be given that leave within a month of that request being made. So you can, if needs be, delay that, but as I said, that right remains, and they still have to be able to take that leave a month as a maximum, a month following that request. It will also be possible to take this leave in days or half days. So you might just want to think about how this is introduced. Obviously, if you are a retail business or a business, that has a lot of staff out serving customers, for example, then this could be potentially something that will affect scheduling. So do think about that as you're implementing the policy. But as I said, it is good news. It's unpaid, so there's no statutory rate attached to it. It is unpaid leave. Moving on, I guess, in that vein, if we could pop on to the next slide, is the extension of redundancy protection. And this is, again, really good news. This has been some while in the making, if you like, has been mooted, but finally been enacted, received royal assent fairly recently. And this extension of redundancy protection, in simple terms, means that where previously an individual that was on maternity or adoption or shared parental leave was away, if there was a redundancy situation, then they would have the automatic right to a suitable alternative role. That has now changed, and so what will happen is that from the point at which, for example, a individual declares that they're pregnant and they're going on maternity leave, from that point and 18 months on, they are protected and able to also expect to be put into a suitable alternative role in a redundancy situation. Now, this, we think, can have a knock-on effect, if you like. So, in practical terms, it's a really good piece of new legislation, because it closes up what unfortunately has been some unfair treatment. But what this does is protects people. But it's worth just thinking about what that might mean, for example, in the way that you deal with selection processes pooling requirements and other things during the redundancy process, because this new right will mean that there will be people that rightly so have that automatic right to roles. The point to bear in mind, I guess, the kicker with this is that if this right is not extended to those individuals, then they do have the right to claim automatic unfair dismissal. So that can be a day one right, and also sex discrimination potentially. So you will want to make sure when you're working with managers that they're aware that this new legislation is protecting those individuals and must be taken into consideration. Okay, so that's the I guess, if you like, that part of family friendly. The other great news is the extension of flexible working. And we are definitely seeing more and more people making flexible working requests. I think it's fair to say that it's commonplace now with hybrid working that people will want to have a more molded work-life balance to what they need in particular, flexible working being one way to achieve that. So if we could pop on to the next slide, please. So the right to request flexible working has been in place for some while. The current legislation says that you can make one request in 12 months, and there is an onus on the employee to share in that request what they would do to mitigate any potential negative impact of the change. What the new legislation does is it says that from the 6th of April, employees will have the opportunity to make 2 flexible working requests in 12 months. And the business continues to be required to consult with those employees. And there is a very set of reasons why a request may be rejected, which the employee will need to refer to, and you'll want to make sure those are in your policies. But there will no longer be the need for employees to explain the effect of the proposed change. So the onus on the employee having to demonstrate the legitimacy of the request is sort of moving off, and there's a balancing here, if you like, of power in the request between the employer and the employee, which is good news, because I guess in my own experience with our clients, these can be difficult conversations to have, and often leaves employees a little bit unsure about how best to approach the request, and needing almost to justify what actually for them is quite an important reason that they need to be able to work flexibly. To underpin that, ACAS are going to issue a new code on flexible working. And interestingly, what ACAS says is that it seeks to encourage a more positive approach to flexible working, which shifts the way of working as well as anticipated changes in the law. So I suppose there again, from a bigger picture perspective, this is all really pointing to this idea that I think employment law is thawing out. It's not particularly as binary maybe as it may appear now, and it is starting to be a little bit more pro-employee in terms of things like flexible working, and recognizing that the way we work today is probably quite different to the way we worked when that employment law was first considered and implemented. So it's good news. With all of these changes, what we would certainly recommend is that you go back and have a look at your policies, make sure, for example, your pay rates are correct, make sure your processes are aligned and ready to go for post-April, and use it as an opportunity to share with your employees some really good things that they can now access, that hopefully betters the relationship between you and your employees. And if you need help with any of that, and I'll talk a bit about that later, then we are here to help. Okay, I'm going to move on then to looking at what other changes there are on the horizon, and a mixed bag, if you like, of changes that are coming up. And if we go to the next slide, I'll share some of those with you. So first and foremost, the allocation of tips workers will be entitled to claim to have back 100% of the tips that they receive without deductions, other than the tax requirements. Great news, I think, for those of you that have got youngsters maybe, or work with people in retail that rely on tips, which has traditionally been one of the attractions of working in retail or areas like that. Again, this was not a particularly great change when the allocation of tips was taken away from employees, but now it reconfirms that 100% allowance is there. I'm going to talk a little bit about the 2P consultation change in a moment, and sexual harassment reform. But the other piece of legislation that we're waiting for is the predictable working patterns legislation. And what this will do is it will give workers a statutory right to request a more predictable working pattern. Employers will have the right to refuse that request. There will be, as I understand it, set criteria, much like the flexible working process that you would follow. But nonetheless, this new right is on its way. I'll also talk a little bit about neonatal care. But all of these things, again, I think if you take a step back, are good news for the employees, because what it does is it provides more certainty, if you like, and more, I think, a sense of security and protection to them in the way that they work and in the relationship they have with us as employers. The challenge, as always, is that the more legislation that we see and we are bound by, the more process we are expected to follow. So I appreciate some of our HR colleagues may be grunting at the thought of having to go through yet more processes, but keep your eye on the fact that actually, from an employee relations perspective, it is quite good news. Okay, so I'm going to talk a bit about the sexual harassment reforms that are coming into force in 2024. Now, this I find particularly interesting. Again, there's been various lobbying around this area in the last 12 months. Certainly more, more in the press. Coming, I think, through what unfortunately is a rise in sexual harassment cases, and we are sadly seeing that as a business. The other thing is that the sexual harassment legislation is potentially somewhat woolly, if you like, around how to deal with it. I think it can sometimes be slightly ambiguous in how it should be interpreted, and therefore the reforms look to sharpen, if you like, our view of how these things should be handled at work, and provide ultimately, again, more protection. So from October 24, the legislation is going to introduce a new duty for employers to take reasonable steps to prevent sexual harassment at work. And what that looks like in practice is making sure that you have the right policies in place, you have training on those policies for managers, and that you reinforce through the culture work that you do, things like induction and all of those other things, that sexual harassment just will not be tolerated. So the point at the moment is that, just to bear in mind, is that employers face liability for any harassment. And at the moment, it's a test of whether they've taken all reasonable steps to prevent it. ACAS is going to support with a code that will sit under that. So if the if the right processes are not followed, or the recommended steps are not taken by ACAS, then tribunals can increase compensation by 25%. So look out for that. The next piece of, I think, quite good news actually, is the 2P consultation regulations, which are changing. And 2P are, for those of you that are not aware, 2P is the legislation that protects employees when they move basically from one employer to another, where, for example, their employer that they work for is going to be removed, and a new employer is going to be providing new services. or the same services, sorry, to an end customer. So that's where 2P applies. And the 2P regulations are somewhat complex and are particularly strict in areas such as making sure people's benefits and terms and conditions are preserved, but also the need to inform and consult, which sits at the centre of 2P. And there again, incidentally, what we are seeing at the moment with 2P consultations is that this is proving to be, interestingly, slightly more difficult in reality for companies to get their minds around. Made difficult to some extent by the need to have elections for employees to choose somebody if they wish to act as a representative for them. Whereas the new 2P consultation requirement will be that where you have consultations, if you have small businesses of fewer than 10 employees, then you can consult with those individuals directly. That doesn't replace where an organisation has trade union presence or reps, and you would still be required to consult with them. So don't totally forget that those people are still going to be in place. But if organisations have fewer than 50 people or fewer than 10, then you're able, as I say, to consult with them directly. And it's also it moves, I believe, to the point where that can be fewer than 10 on one site rather than in the whole organisation. But I would just check that out. So that's, I think, we're waiting to be confirmed. Okay. So that's 2P and carers leave. I'm going to move on now and talk about some of the notable employment tribunal cases that happened last year, just to try and help a little bit with some of the things that we are seeing, if you like, that are still unfortunately problematic out there. So if we flick on to the next slide, the first one I thought was worth calling out was Higgs versus Farmore Schools, and this was a religious discrimination case. Interestingly, so Mrs. Higgs was a Christian, and her views were that same-sex relationships and gender fluidity are prohibited by the Bible. And Mrs. Higgs made various posts on Facebook to share her views and objecting to the manner that sex education was being taught in the school. Not surprisingly, the parents of the children in the school complained, and Mrs. Higgs was subsequently suspended and dismissed. And at tribunal, the employment tribunal found in favour of the school. And what Mrs. Higgs then did was go on and raise a further appeal. And at the employment appeal tribunal, they overturned the decision and deemed that the dismissal was unfair. And interesting to note here, I guess the point of this is that the employment appeal tribunal said that employers must recognise the importance of the right to religion or belief, even where that belief is not popular and may offend. So it stands as a really interesting example in a very, very complex area, if you like, around how we have to be careful how we navigate the right for people to have views of their own versus where those views might be considered discriminatory or reputationally damaging. And as you've heard from that, even in the tribunal service, the employment tribunal and the employment appeal tribunal had very different ideas of that. So always, when you find yourself in this space, give us a call and we can help you navigate that as best that we can. The second interesting piece was the Chief Constable versus Agnew. Again, you may have heard about this more in the press in relation to the calculation of back pay for holidays. And this raised the question last year of how far back a claim for underpayment of holiday should go. Unfortunately, because it was in Northern Ireland, there was quite a sting in the tail with this case, and in admitting that they hadn't actually maybe calculated the back pay correctly, now face a fairly large bill. What it does do, though, again, is just to serve as a reminder that you must make sure that when you are paying back pay, that pay the definition of pay should include commission and overtime, and you must make sure you calculate that correctly. The issue with the Agnew case here being that holiday pay didn't include overtime and other elements, which is to their credit, the police service put their hand up and recognised that, but unfortunately have a whacking bill in the process. Interesting one here, I thought, advertising sex work online. So this case was brought by a former NatWest employee who advertised sex work online and won a case for unfair dismissal, and that was due to flaws in the disciplinary process. So again, quite an interesting case. The claimant ran a website. He offered explicit pictures of himself and a £25 sensual massage whilst he worked at the bank and where he was employed. I don't think, just for the record, he offered them at the bank. I think from what I see, he offered them outside of the working hours. His manager confronted him, told him that actually it was reputationally damaging for NatWest. Interestingly, in response, the employee then responded by accusing the manager of cyber stalking him. That battle, if you like, went on for some time, and eventually the employee was dismissed because essentially he kept having fallouts with his manager. What's interesting here is that the occupational health report that followed showed that the employee was prone to low mood and was diagnosed with bipolar disorder, and he was therefore deemed fit for work if reasonable adjustments were made to avoid triggers. And so this again serves, I guess, whilst interesting, this serves to remind us that where we do have individuals that have conditions or are maybe misbehaving, what we do need to make sure is that we look behind that and consider what might be creating that behavior, what we might need to do reasonably to support that, and not just assume, I guess, instantly that maybe if something's not quite right, then it's automatically okay to dismiss, because that's often not going to be the right answer. And then finally, an interesting question here: what happens when you combine work, a tarantula, and a snake? And this, to finish on the cases, was a really interesting case that involved a train driver's prank. So the train driver, Mr. Richardson, had been working for West Midland Trains since 2018. Had a conversation with his colleague in the train driver's mess, and she told him that she was squeamish about insects and spiders. And so Mr. Richardson thought that it would actually be fun to play a prank on the colleague, and he placed a tarantula's exoskeleton in her pigeonhole. Those of you that might be squirmish around snakes and spiders will equally be unsurprised to hear that she called him, on finding that, an extremely explicit name, and left and reported it. He thought that prank, given that she responded so badly the first time, would maybe be fun to run again. So he then put a snake skin in her pigeonhole, and again she reported it, and he was subsequently dismissed. What was interesting was that the tribunal acknowledged, the tribunal heard from Mr. Richardson that he did not understand why the female colleague was so upset, and the tribunal found, and again interesting in itself, that he had intended to not intended to upset her, no matter how poorly the prank proved. So a lesson there again around making sure that if you're going to play pranks with the team, for goodness sake, don't use spiders or snakes or anything that's going to cause any element of distress. Okay, so moving on then, there's been quite a lot there for us to think about. In summary, what you need to go back and make sure you do now is think about risk areas. So reflecting back a bit, there's the change in redundancy, in the protection for redundancy for maternity, shared parental leaves, individuals. So reframing, I guess, that to make sure your processes allow for them to automatically be put in a suitable alternative role. There's the 2P piece, which is about then making sure that you hopefully take advantage, dare I say, of the opportunity to consult with employees directly for the smaller organisations, and the other family-friendly changes and monetary changes, the rates change for that. So do go back, have a look at your policies, and then spend some time thinking about how you'll roll that out. There are some good news stories in those changes that you could use then to share with your employees, to show that not in the least that you are keeping up with what's expected of you. And finally, making sure you have the right HR advice in place. And that's really important, because what you have seen also is that there is a continued tightening up of expectations in some quite sensitive areas. You know, the sexual harassment reforms, for example, will place more onus on employers to show that they're operating in the right way. So talking of which, just to finish, I'll talk a little bit about who we are. We are, as I said, the HR department. We are an outsourced provider of HR support, and we operate across the Southwest London area, and we work with smaller businesses in all range of things. So we are essentially a HR department as you'd know it traditionally, but we are outsourced, and we have a whole range of clients. We have about 75 clients that we work with, everything from supporting employment contracts and handbook production through to complex employee relations cases, training, benefits, recruitment, and anything else that people need. So we're quite tuned in, if you like, to what's happening out there at the moment, and like to use our experiences to help our customers stay on the right side of the law. If we scroll back a slide, I just wanted to share with you that we are running other events. So in April, we're going to be running a recruitment event, which looks at how to attract and retain great talent. Recruitment is an area that we talk about almost every day. Everyone's facing problems with recruitment. So we're going to share some of the secrets of what we found to work well and what you might want to think about. One of the big needs that we're going to be addressing this year is the need for more management development. And so we run a great management development program in person that's going to be happening at the start of June, alongside which we're going to be running a HR basics workshop. And that's all about the key things beyond employment law that you need to know to run your HR function successfully in-house. And then just flicking on a couple of slides, we do have a drop-in. So every Tuesday, I'm available to talk to entrepreneurs, managers, HR people that maybe need to kick other things around they're struggling with, to have one-to-ones to discuss to discuss challenges and concerns. You can book a slot with me through this link, and we'll send that out to you. But that's free. There's no obligation beyond any of that. So it's just a space I find people like to use where maybe they don't have someone to talk to in the business to talk through problems they might be having, and hopefully, apart from good coffee, we can help them help solve that. And the other thing that we are also providing shortly is our free HR audit. So we have a great audit document that you can use to assess how compliant your HR function is. And do contact me if you're interested in finding out more about that. And I'm happy to talk that through. And any element of the information that you've had today, I'm also happy to talk through. And very finally, before I move to questions, do stay connected. Obviously, you've picked us up on Eventbrite, and we're delighted about that. Here are our details. We're on all of the platforms: LinkedIn, Twitter, Facebook, and obviously on the web. So do please sign up. We do like to offer free newsletters and other information that hopefully will help you in navigating this very complex landscape that we work in terms of people. So that's it. I'm going to turn now to chat and answer some questions. Okay, so question from VJ. Hi, VJ. If someone close relative or parents dies, how many days he or she can qualify for holiday? So there is bereavement leave. It's fairly limited at the moment, and you tend to find with bereavement leave, it's more of a company policy. So refer back to your company's policy on that. But there is allowance for bereavement leave for bereavement under the age of 18. If you've got specific questions on that or need more information, then reach out, VJ. Happy to help. My email details hopefully are on the screen. Jen, what would be a justified reason for leave, or is there not a requirement to give a reason for carers leave? Yeah, good question, Jen. As I've seen it, it's really that you have an individual that might be slightly dependent on you and needs support, is essentially as I've read it. I don't think, give me a second, I'll flip back to my notes. I don't know if there is, in fact, I don't think there is a definition of that. So give me 1 second and I will quickly check. No, there's no definition. So it's for the nearest we get is to arrange care for a dependent with a long-term care need. Again, so that seems to be as defined as it gets at the moment. Tatiana, are there regulations for the instances where an employer still refuses to pay tips for the service charge? Yeah, there will be a penalty for those that don't do that. Likely, I would imagine that it'll need to be logged with the tribunal service. And I imagine, and I haven't seen this, but probably will fit into something like a failure to pay wages or in that sort of area. So. Thank you, David. Thanks, Catherine. I appreciate all of your feedback. Thank you. Sabida's phone. What are the consequences if a manager is not complying with appraisal agreement? Again, there's nothing strictly in employment law that deals with that, Sabina, but there may be things in your own company policy that would respond to that. So maybe check back on that. Okay, well, thanks so much. It's been a real delight to talk to you. My many apologies again for the technical hiccups at the front, but we will send out the slides to you. Do please get in touch if we can support you in any way. And thanks again and all the best, and see you soon.